You've probably heard terms like foster care, probate court, guardianship, conservatorship. We are a firm that focuses 100% on planning our clients' estates to make sure that those terms are not terms that infiltrate your life.
Let's get to the basics. What should be included in an estate plan? In your estate plan, you should have a living trust, wills, financial powers of attorney, and healthcare directives. A living trust is a document that's set up where you nominate successor trustees to manage your assets for your heirs in the event you are no more. Why do I need to set up a living trust? Well, if you have checking, savings, brokerage accounts, you own any real estate, these assets go through this process called probate, which is a time-consuming, very emotionally draining process. Not only that, your assets are exposed to your creditors during this process, and also you do not get to control how your assets are distributed amongst your heirs. The court gets to decide that. So by setting up your trust, you get to nominate successor trustees who will follow the guidelines you leave behind within the trust. So not only do you get to avoid probate court, but you get to control the estate in the event you are no more.
Guardianship is essentially who would care for my children if I were not here. I want to be sure that I've nominated individuals who are like-minded to me, who will care for my children in the way that I need them to be cared for. The alternative is foster care. The alternative is a judge making a decision and determination about where your children should be raised, on what terms they should be raised.
A third element of your entire estate plan is the financial power of attorney. A financial power of attorney is a document that we put into place today that says, if I'm ever mentally incapacitated, I'm unable to make financial decisions for myself, I nominate these individuals. And why do you want to set this up? Well, if you do not set up your financial power of attorney, your loved ones have to go to court and get a conservatorship over you. They need to ask permission from the court and be granted this authority to enter into legal documents, sign your name where it's required. And if you do not have this financial power of attorney, this process is, again, time-consuming and very costly. So we're trying to bridge the gap here by having this financial power of attorney in place. And if you're married, it doesn't automatically go to your spouse. You have to define that also within your estate plan and within this financial power of attorney.
A healthcare power of attorney will be one of the documents that we draft for you in your estate plan. Your healthcare power of attorney allows you to nominate individuals who will carry out wishes for you if you are in a hospital and unable to make those decisions on your behalf. A healthcare power of attorney also allows you to preemptively make some decisions that you don't want your nominees to have to make on your behalf. You're taking the stress away from your nominees. Decisions about life support, decisions about being buried versus being cremated, decisions about donating organs, whether to donate or not to donate. These are all decisions that we want to make on our own behalves, and we don't want other people to have to debate those issues for us. So that's what your healthcare power of attorney will allow you to do.
It's so important to set up your estate plan, because if you do not, you are going to leave those you leave behind in disarray, confusion. They're not going to know where to begin. By setting your affairs in order, not only are you leaving your legacy behind, but you're also preserving the integrity of the family, and you're making the grieving process for them that much easier.